Hey there, and welcome to another Q&A with me, Giselle Carson, corporate immigration and compliance attorney. In just 2 weeks, we have had an amazing array of news in the immigration front. And this Q&A, I have particularly selected the topic of adjustment of a status because obviously I'm receiving a lot of questions based on the latest policy shift and direction to USCIS on how to adjudicate cases on adjustment of status. And so I will cover that in this Q&A. But I also want to mention that last week we had an important court decision, federal court decision, Dorcas v. USCIS, that has a national impact on cases that have been paused by this administration. So on Monday of this week, I released an immigration flash that outlines what we know about that decision and its impact. If you follow me on LinkedIn, or if you don't, you can go and find me on LinkedIn, and you will see a link to that summary. And on the 100K decision, so that's the decision that came this week, literally just yesterday. So I'm recording this on Tuesday, June 9th. And that decision vacated, at least for now, the $100, the 100,000, the 100K fee. There's so much going on that my brain is having issues concentrating on it all. But that decision was vacated yesterday, and that affected certain H-1B applications, particularly those that have been applying from abroad or that needed to cancel a process. So I will provide more information on that one. So again, those are two key decisions that have come down literally in last week, those two that are going to affect immigration processing going forward. As to both of them, again, they both have national impact, which is great because sometimes we get decisions that are very limited to the parties that were in the lawsuit or otherwise. Now, as to both of them, we have heard and we expect that USCIS will appeal them, ask for a temporary stay. Who knows what they're going to do, but there will continue to be litigation on this, and USCIS has not provided guidance as to how they're going to treat these decisions. Now, they're federal court decisions telling them what to do, but as we know, they're going to likely be very slow on releasing anything. And so we will continue to follow and we'll continue to provide updates. With that in mind, let me turn into the adjustment of a status situation. That is what I had told you that I was going to talk to you about. Again, there is much to be learned as to how this is going to eventually apply. And it will likely apply differently to various visa categories and whatnot. But let me kind of tell you where we're at. So first, I want to clarify what adjustment of status is. Adjustment of status allows a foreign national that is in the United States, invalid status, to apply to adjust their status from whatever status they're on, say an H-1B or an L or a TN, to a green card at the end of the day. And before the adjustment of status is applied for, there's many steps that need to happen before we get there. But say, for example, on an employment-based case, which is the great majority of the cases that we do, the I-140, the immigrant petition, has been approved. The priority date is current. And now we're ready to make the decision. Are we moving forward with an adjustment of status? So again, that allows a person in the United States, foreign national, to apply to change their status from whatever they're on to a green card. And that the form that is used for that process is Form I-485. So you may also hear that. I file the I-485, kind of file the I-485. That's the form that is used for adjustment of status. So that's the basic background. Now, also, adjustment of status, for as long as I've been practicing immigration law, which is over 25 years now, hard to believe, and way before that, has been a very well-established path to, in fact, I'm an immigrant, used adjustment of status to adjust my status from an H-1B to a green card. And this was 40 years ago. Anyway, so it's a very well-established process that now this administration has put it into question. So what has changed? Again, adjustment of status has not gone away. It is here to stay. It is a very well-established process. What the administration now has says, and the new policy, directs USCIS to remember that adjustment of a status is a benefit, and it's a discretionary benefit that USCIS, even if the person is fully qualified to apply, that there is more that should go into the determination as to whether someone is allowed to adjust status in the United States, because it is a discretionary benefit. And if the person cannot adjust in the United States, the alternative, which according to this policy memo is the established way to do it, is to go abroad and cancel a process, a green card. And just as a side note, also cancel a processing a green card is obviously takes the person outside of the United States, sometimes for a very long time. The consulates are already backlogged with a lot of the stuff that they have going on. USCIS is a much better position to adjudicate these transitions from a non-immigrant visa to a green card. So again, what has changed is the direction or the directive to USCIS as to how to adjudicate these cases. Under this policy, meeting the legal requirements is not enough. The USCIS will now weigh the positive versus the negative factors. And those are, more to be determined, but I'll show you what has been considered positive and negative factors. And they will make that determination before they decide whether to approve, whether to issue an RFE, or whether to deny the case. And also simply having no negative factors is also not relevant enough. So if you have, and again, I'll touch on the positive and negative factors, but even if you have a very clean record and full eligibility, that will not be enough according to this policy. Now, USCIS has said that they were going to provide further guidance on this. That is yet to be seen. What we are following is really the practical application since the policy came into place. What has actually happened? What are USCIS doing when someone applies for an adjustment of status or goes to an interview? And it's those practical tips that is so important for you to know, and that is what I intend to continue to pass to you as we see and hear how this evolves in practice. Now, many of our clients are in H-1B status or L visas. Both of those visas are called dual intent, meaning that you can have the intent of having a non-immigrant visa like the H or the L, but also you have the intent, the disclosed intent to become a green card holder eventually. So we expect, actually, the new policy acknowledges that the H1 and the L1 are visa categories that have dual intent and allow the foreign national to pursue a green card while also maintaining this non-immigrant status, HS or L. But again, it also warns that being an H and or L status and not having any negative factors is not enough to grant the green card like it has been the case in the past. So we'll see again how this evolves, but at least it is good to know that USCIS at least is recognizing the dual intent of these categories in their memo. Something else that I wanted to talk to you about is not quite often, most of our clients do not do this because we advise them not to do that, is to give up their underlying status. So for example, they're, and I'm just taking as an example, Indian nationals, just because they have such a long path before they actually get to a green card. Some of them have an H-1B, an underlying H-1B, and somewhere along the way, after they apply for adjustment of status and they're able to obtain an employment authorization document, but they still have to wait for the actual green card to arrive or to be able to process. They give up their non-immigrant status, their H-1B, their underlying status. And that now can create a significant problem for people in those situations because they're truly just relying on this adjustment of status. And, right now, something that we never expected before, that adjustment of status discretionary benefit is being questioned. So if you're listening to us, if you're or me and you're one of our clients, for sure, do not give up your underlying status until you actually have a green card in your hand. This day and age, we actually need to make sure, or at least encourage you to protect every avenue to have legal status in the United States. So, something else that I said to you at the beginning that I'm going to start giving you some guidance or insights as to what we're seeing in practice. For those that have attended an adjustment of status interview since the new policy was issued, here are some of the questions that they are getting, and something also to consider for us and for those thinking of applying for adjustment of status. Certainly for our clients, when we start thinking about adjustment of status going forward, I am going to think of these questions and proactively answer them as best we can in the filing, and certainly prepare them for an interview that would include these questions. And again, this is what we're seeing now. The questions, and it gives you an idea as to what the adjudicators have been told to start asking and thinking. So the questions that we are seeing include: why did you apply for adjustment of status instead of consular processing? Are there any factors that would prevent you from consular processing? Why did you remain in the United States after your non-immigrant status or your authorized period of stay expired? So this one actually ties back exactly to what I just talked about before. For those that have abandoned, let go of their non-immigrant status, they're going to have to start answering this question as to why did you remain in the United States after your non-immigrant status expired? And what family or the other ties do you have to your home country? Okay, so those are the kind of questions that are being asked right now since the new policy came into effect. Now I'm going to talk about a little bit about the positive factors. Negative, well, let me say to you, negative factors start there. Will include things like violation of immigration laws, violation of prior status, fraud or false testimony, inconsistency in the record, and those, I mean, the negative factors, the list could go on, but typically something that is, against the law or a violation of some sort. Now, positive factors, again, that list could be very large or very small, but it is really going to depend on a case-by-case basis. So here are some of the things that we are going to be looking at. Family ties in the United States. For example, if it's the H-1B principal and they have an H-4 spouse, they have kids in the United States, that would be certainly a positive factor that we will bring forward. The applicant's moral character. So have they received, have they pursue certifications or licensing, or are they involved in the community in some way beyond their job? Those are all considered positive factors. Also, the impact that the employer will have if this person has to leave the United States for 2, 3, 4 months, an indefinite amount of time, until they come back into the United States. Arguably, it is in the economic interest of the employer and our country that this person continues to be in the United States and contributing. So those are the kind of things that, again, we are going to be talking to with our clients and as we evaluate the cases. I also have to tell you, currently we have a few adjustments of the status that are actually ready to move forward. And I am grateful to our clients that they're kind of helping us pause with them and just kind of see how this evolves before we jump in the waters or in the pool. Particularly as, TM workers and whatnot, where we could be filing an adjustment of status right now, where we're kind of holding back to see how this evolves so that we put the best foot forward once we move to adjustment of status. So I hope that this has been helpful. Again, this will continue to evolve, and I'm here to continue to provide you with practical, simple, hopefully, advice so that employers that hire foreign talent, and again, congratulations and kudos to you, because they are a significant portion of the workforce of our current workforce and the future workforce. And for you foreign nationals, literally I have I put little phrases for myself every day to kind of guide my day. And for the last week or so, I've had the word steady amidst the chaos. Be steady and be a positive force. Some of you also, this is in a personal note, have followed my journey to being a 7 continents marathon finisher. So this is my medal. My team have seen this medal. I think I showed it, well, not this one, but a picture of this one because I didn't have it. Now I've earned it. This is mine. I have now completed a marathon in all 7 continents. And yes, that includes Antarctica. And my last one was in South Africa, in Cape Town. So this is my medal from the South Africa Marathon. And I'm showing this to you because it has been a long journey with many ups and downs. You can imagine running a marathon in all 7 continents. It's not potentially for the faint of heart. It is, and similarly, is not immigration law. And I use my skills, mindset, endurance, resilience from all my endurance events and activities that translate to the work that I do. And I'm so grateful for the resistance, the resilience, the mindset, the steady approach that I take to things that are helping me practice immigration law and continue to contribute to you, to our clients, to our listeners, to our country in the most meaningful way that I can. So thank you for being here. If you're not a subscriber to the channel, I encourage you to do so that you can get the alerts when I get this updates. And again, my intent is to give you things that are practical, useful, not creating noise when it's not necessary. So thank you for being here. I'll talk to you soon. Bye.